And these are a list of misdemeanor cases in which individual cases have already been accused, bonds have been set. And today is going to be plea and arraignment issues, as well as bond modifications and probation revocations. If you're a defendant accused of one or more misdemeanor offense, please remember that you have a right to remain silent. Anything that you choose to say in open court, which is not only being recorded but live streamed, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one will be appointed to represent you. Courtroom 2 or ACDC, where should I begin?
Good morning, Your Honor. Position 20 at ACDC.
Okay, thank you. We have Ms. Jasmine Hartnett. Is Ms. McLeod? Good morning. Do you represent?
Good morning, Your Honor.
Morning.
This is going to be a negotiated plea this morning.
And Ms. Jasmine Hartnett, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. Your case number is 21 CR 4654A, in which you have 3 misdemeanor charges: simple battery, theft by taking, and a battery of a particular nature. We are going to waive sounding on that particular charge. This is going to be a negotiated plea hearing. May I place you under oath?
Yes, Your
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Ham, good morning.
Good morning, Your Honor.
All right, sir. And it looks like it's going to be time served, 12 months, served 12 months on each count. Would that be correct?
Yes, Your Honor.
Anything else to add?
Nothing else to add, Your Honor.
All right. And Ms. McLeod, does your client stipulate to the factual basis, venue, and ID?
She does, Your Honor.
Okay. Ms. Hartnett, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood what's been going on so far in your case?
Yes, Your Honor.
Are you satisfied with your legal services?
Yes, Your Honor.
And is anyone forcing you to plead guilty to these charges today?
No, Your Honor.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your attorney, to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to the 3 charges brought against you?
Guilty, Your Honor.
All right. Your sentences are going to be concurrent for each charge, and it's going to be 12 months to serve 12 months. And that concludes your case. You have no further obligations in this matter. If you have no other cases holding you, you should be released within the 24 hours. Otherwise, you will have to address your other cases. Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, Ms. McLeod, you have a good day. Thank you.
You too.
All right. Mr. Doty, good morning, sir. Who are we addressing?
We can go with position number 1 and 2, Mr. Abdullah.
All right.
Good morning.
Good morning. This is Mr. Sulaiman Abdullahi.
Yes, ma'am.
Case number 19 CR 5414G, in which the accused is charged with criminal trespass from June 22nd, 2019. The second matter is a bench warrant from May 10th, 2024. Mr. Abdullahi, you've been advised of your right to remain silent, and your attorney is Mr. Angelo Doty. May I place you under oath? Do you
Yes.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham, yes, sir. What is the recommendation for count 1?
Yes, Your Honor. For count 1, state's recommendation is 12 months to serve 44 days, credit for time served 22 days, balance suspended, and to stay away from 270 Winding River Drive. As it relates to position number 2 on the calendar, the state will move to non-part stay.
Mr. Doris, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We do so stipulate, and Mr. Abdullahi does accept the state's offer.
All right. Sir, Mr. Abdullahi, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's been going on in your case?
Yes, ma'am.
And are you satisfied with the legal services you've received?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
I'm guilty.
All right. Your sentence is 12 months to serve 44 days, credit for time served 22 days, balance suspended. Your obligations for this case are over. However, you cannot return to 270 Winding River Drive. I assume that's in Atlanta, Georgia. Would that be correct? Okay. And for your bench warrant, that's going to be dismissed. So that concludes your cases. Thank you.
Next, we can go to position number 9 and 10. Ms. Roget Cole.
Mr. Dotis, is that Roget or Roger? Are we looking at a typo?
It's Roger.
Okay. All right, sir. This is Mr. Roger Coles, case number 23 CR 5777H, accused of terroristic threats and acts, fare evasion, and public drunk. And he's also got a bench warrant, 24 FTA 753. Mr. Coles, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. May I place you under oath for purposes of your plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Mr. Ham, and what is the recommendation for Mr. Coles?
Yes, Your Honor, for Mr. Coles for position 9, the state's recommendation for count 1 is 12 months to serve 28 days, credit for the time served 14 days, balance to be served on probation, to complete 12 weeks of anger management, and also to complete 40 hours of community service. For count 2, fare evasion, the state's recommendation is time served. For count 3, public drunkenness, the state's recommendation is time served. As it relates to position number 10 on the calendar, the state will move to non-pros that case.
All right, thank you. Mr. Dotis, do you so stipulate, and does your client accept these terms?
Yes, Your Honor. That's our understanding of the plea, and we do so stipulate to the 3 elements.
Mr. Coles, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
No. Yes, ma'am.
Has anyone forced you or induced you to enter a guilty plea today?
No, ma'am.
And you understand that if you plead guilty, you will not get the opportunity to have a trial. You will not go back to court to confront your accuser and challenge the evidence brought against you, as well as have the state prove the charges against you beyond a reasonable doubt.
Yes, ma'am.
Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead to terroristic threats and acts, fare evasion, and public drunkenness?
Guilty.
On the terroristic threats and acts, your sentence is 12 months to serve 28 days, credit for time served 14 days. You've completed your jail time, and if you have no other cases holding you at the jail, you will report to probation this Thursday. Probation is located at 132 Mitchell Street at downtown Atlanta. You must report to the office before 3 p.m. Is that possible, Mr. Dotis, or does he have a hold?
Your Honor, I do not believe he has a hold. I can double check. But while we're on that subject, Your Honor, we would ask this court to consider waiving a few months of his fees so he can get back on his feet for probation and allow him to switch to non-reporting status upon completion of the classes and community service.
All right, presuming that he reports this Thursday, then I will waive his probation fees up to and including the end of August 2024. After that, he will need to start paying probation fees from September 1st onwards. While he's on probation, he will start a 12-week anger management program, and he must enroll in those classes within 45 days of being released. He must also complete 40 hours of community service at any nonprofit agency that's not a church and not a school. And you must begin with a minimum of 5 hours per month and complete 5 hours every month thereafter. With regards to count 2 and 3, the sentence is to serve 14 days, and that's been completed. Thank you.
Thank you, Judge. One more question. You can ask me.
The bench warrant is dismissed.
Is the class on Zoom? Okay. You'll be able to.
I'll bring my phone up and you set up.
Appreciate it. That's what.
Next, we can go to position number 11, Mr. Davis.
All right, Colonel Lakeith Davis is accused of willful obstruction of an officer, expired or no license on person, failure to signal lane change, and giving false information to an officer from February 21st, 2018, under accusation 19 CR 9738B. Mr. Davis, you've been advised of your right to remain silent. Your attorney is Mr. Dotis, and may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you. Recommendation, Mr. Ham?
Yes, Your Honor, for position 11, state's recommendation for count 1 is 12 months to serve 40 days, credit for time served 20 days, the balance to be served on probation, to complete 40 hours of community service, and to pay a $300 fine. For count 2, expired or no license on persons, the state recommendation is 12 months to run concurrent, 12 months probation to run concurrent with count 1 and to pay a $210 fine. For position 3, failure to signal lane change, state's recommendation is time served. For count 4, giving false information to a law enforcement officer, the state's recommendation is time served.
All right. Mr. Dotis, do you so stipulate, and does your client agree?
Yes, Your Honor, we do so stipulate. I went over with the offer with Mr. Davis, and he did agree to the negotiated plea. Given the age of the case, we would just ask that probation terminate upon completion of community service and the fines. And I did note on the probation sheet, he does have a hold in Cobb County. So I wanted to make it clear to them that he's going to report, and he has the information to do so upon his handling of the matter in Cobb.
All right. And Mr. Ham, any objection to termination once he's completed his conditions?
No objection, Your Honor.
All right. Mr. Davis, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
And has it been explained to you that if you plead guilty to these charges, not only will there be points added to your driving history, but you will also have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the chance to confront your accuser, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to misdemeanor obstruction, having no license on, having expired or no license on person, failure to signal a lane change, and giving false information to an officer?
Yes.
The willful obstruction sentence is 12 months to serve 40 days, credit for time served 20 days. Once you have resolved your Cobb County hold, you have to come back to Fulton County and report to Fulton County Probation on the first available business day. The probation office is located at 132 Mitchell Street. You will report to the probation office before 3 p.m. While on probation, you will complete 40 hours of voluntary community service and pay a $300 fine. For the no expired or no license on person, it will be 12 months concurrent with count 1 with a $210 fine. And for counts 3 and 4, that would be to serve 20 days, credit for time served 20 days. So that one would be a time served. Please remember to report to probation immediately after you're released from Cobb County. Once you've completed the community service and paid off your fines and probation fees, your probation will terminate. Thank you.
Next, we can go to position number 15, Mr. Aaron Frazier.
This is State versus Erin DeMarco Frazier, accused of battery from June 10th, 2024, under case 24 CR 3629D. Mr. Frazier, you've been advised of your right to remain silent. Your attorney is Mr. Dotis. Mr. Dotis, are we still maintaining this as a non-negotiated plea?
Yes, Your Honor, and our only concern is jail time.
All right. Mr. Frazier, this is going to be a non-negotiated plea hearing. May I place you under oath in the event we go forward with a plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. The prosecutor is going to give me a recommendation, and then your attorney will give me an alternative recommendation. I will let you know which option I will select, considering I also have the option to disregard either recommendation and set this case down for trial. Mr. Ham, what is the state's recommendation, and if you want to allocate the reasons for them?
Yes, Your Honor. The state's recommendation is 12 months to serve 60 days, credit for time served 15 days, the balance to be served on probation, to complete 12 weeks of anger management, also to complete 40 hours of community service, and to stay away from the martyr located at Peachtree Street, and have no further contact with Kevin Harrington. Your Honor, the factual basis for this plea is that on June 10th, 2024, Water Police responded to the Peachtree Martyr Station. They made contact with the victim in this case, who advised that the defendant attempted to take his bike from him. When he confronted him about taking his bike, the defendant told him he would beat him up. He attempted to grab his bike, and that's when the victim attempted to grab his bike, and the defendant began to punch him in the head. The defendant also bit the victim in the head and refused to let go of the bike. And he didn't stop until the police came. Your Honor, based upon that surveillance incident, and this incident was caught on camera, based upon that and his history, he has 21 cycles. He had a robbery that was reduced to theft by taking out of DeKalb County, 15 CR 1676. He also had a battery family violence that was reduced to disorderly conduct out of DeKalb County, 16 C 99478. And he also has a battery conviction out of DeKalb County, 18 C 16225-4. So based upon this current incident in his history of robbery and battery, we believe that this sentence is appropriate.
Thank you. Mr. Dotis?
Thank you, Your Honor. As stated, we're fine with all conditions of probation. We would just ask it to be served 30 days, credit for time served 15 days, so that Mr. Frazier can get started on the 12 weeks of anger management and the 40 hours of community service. I spoke with Mr. Frazier yesterday, and I also spoke with, he told me a little bit about his personal life, and he gave me a number of his partner's mother to call. And she confirmed this information to me. Mr. Frazier is the primary provider for his long-term girlfriend. She does have chronic health issues that Mr. Frazier is primarily takes care of her, and it has been a hindrance on her and her mother with him in custody. So we want to make sure that he's able to continue caring for them. I would also note, it looks like his last conviction was in 2018. Your Honor, I believe that the 12 weeks of anger management and the 40 hours community service, in addition to 30 days of jail time, would be sufficient for this. And, again, we want to make sure that Mr. Frazier is able to successfully get started on this probation. He currently has a job waiting for him at the Luxury Pro car wash. As of today, he can go back, but he's not sure if that job would be waiting for him if there was any more prolonged incarceration. So, Your Honor, we would ask that you allow him to get started on probation and set any conditions to ensure that he gets started promptly. And if he doesn't get started promptly, he understands he would have to address that.
All right, thank you. I remember this case, and I was also wondering why it was not upgraded to a robbery by force. And given Mr. Frazier's significant history, including his prior arrest and conviction for robbery, and considering the elements of the warrant and the allegations in this case, I'm accepting the state's recommendation. Mr. Frazier, for these reasons, I believe that the state's recommendation is very reasonable. And furthermore, I don't see anyone on Zoom here with regards to your girlfriend or your mother indicating any kind of support. Given your criminal history record, you will be serving 15 more days before you're placed on probation.
And Your
Would
Honor,
you, just
I-
one second, yes, Mr.
Can I-
Doty?
Can I speak with Mr. Frazier? before
That's
we-
what I was going to ask you. Could you please talk to him and see what he'd like to do?
Your Honor, at this point in time, after speaking with Mr. Frazier, we'd ask the court to allow us to withdraw his plea.
Okay. In that case, then I will arraign the case. And Mr. Dotis, would you like to file a waiver of arraignment, or would you like me to arraign the case?
Your Honor, I'll file a waiver of arraignment. We would ask to address bond today.
The bond is set at $1,000. And is there anything else more extraordinary from June 11?
Again, Your Honor, just the time that has surpassed, and again, he does financially, in addition to his partner, that he is the primary person responsible for her care. He also has a 10-year-old child that he financially provides for. He also did let me know that his mother passed a few weeks ago. So he's really on his own and trying to provide for his family. Your Honor, at this time, we just ask for a signature bond through pre-trial to ensure that he's reporting, and he knows that he will have to report to court. Anything you want to say?
Mr. Ham, any objection to a modification?
Yes, Your Honor, based upon his history, in addition to that, he has several probation violations in which he failed to comply with the order of the previous judges in regards to his cases. So based upon that, Your Honor, we would object to any modification to his bond.
Mr. Dotis, unfortunately, I was the one who did first appearance, and I remember this case. Like I said, I was curious to know why these charges were not upgraded, but given his criminal record history, and this is the lowest bond that I set, given the circumstances. Bond modification is denied. This case is further notice for trial. Thank you.
Understood, Judge.
May we address the next case, please?
Next, we could go to 16 and 17, Levon Garrison.
All right.
And Your Honor, this is a negotiated plea, but I did want to confirm the correct jail time, if Mr. Ham can also confirm this. I have that he has credit for 13 days, so it's a time served offer, so I would just ask it to, if Mr. Ham's okay with it, to just say serve 26 days credit for time served, 13 days.
I have 40 and 20. So
I-
40 credit for time served 20. Has there been a change?
Your Honor, my understanding was there's an issue with this booking number not being linked. So my concern to this case, my concern was it might continue holding him. I was unable to see, I see Mr. Ham did mark an additional time where was getting credit for this. I just was unable to find that.
Mr. Ham, do you have anything to that effect?
Yeah, I do, but just to make sure it's clear on the record, I will reduce it to 26 credit for time served, 13 days, because that's what's currently shown on his booking screen.
26 served, 26 credit 13.
Yes.
Would that be consistent with what you're requesting, Mr. Dotis?
Yes, Judge.
All right.
Thank
Sorry, go ahead. Anything else?
Nothing further, Your Honor. Thank you.
This is Levon Greg Garrison. accused of giving false information to an officer and misdemeanor possession of marijuana under 17 CR 17530H. He's got a bench warrant under 24 FTA 751 from November 17, 2023. Mr. Garrison, you've been advised of your right to remain silent. Your attorney is Mr. Dodis. And may I place you under oath for purposes of this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham?
Yes, Your Honor, for position 16, state's recommendation for count 1 is essentially time served, 26 days, credit for time served, 13 days. And for count 2, possession of marijuana, that's been announced, state will move to null pros that count.
Mr. Adonis, do you stipulate?
Yes, sir, we do so, yes, Your Honor, we do so stipulate to the 3 elements and the plea is to our understanding.
All right. Mr. Garrison, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
And has he explained to you that if you plead guilty to these charges, you would be giving up your constitutional right to a trial? You will not get the chance to confront your accuser, have the chance to have your attorney assist you to challenge the evidence brought against you, present your defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to giving false information to an officer?
Guilty.
Your marijuana charge is null prost and your bench warrant charge is null prost, which means they're dismissed, and the false information charge is time served, which is to serve 26 days, credit for time served, 13 days. That concludes your cases. Thank you.
I apologize, Your Honor, for position 17, the state will move to null pros that.
All right, so noted. Thank you.
We can go to position number 18, Mr. Willie Grace, Olivia.
Willie Grace?
All right, good morning, Miss Olivetti. Vigiletti, excuse me. Olivia Vigiletti. I got the two mixed up. Thank you. Miss Vigiletti, how are we proceeding on Mr. Grace's case?
Mr. Grace would like to enter a negotiated plea this morning.
All right. This is case 24 CR 3627Y, in which Mr. Willie Grace is accused of criminal trespass causing damage to property from June 7th, 2024. Mr. Grace, you've been advised of your right to remain silent. Your attorney is Miss Vigiletti. And may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham, the recommendation, please.
Yes, Your Honor, the state's recommendation is 12 months to serve 32 days, credit for the time served 16 days, balance suspended, and to stay away from Fellini's Pizza located at 909 Ponce de Leon Avenue.
Miss Vigiletti, your client agrees to these terms, and do you so stipulate?
Yes, Your Honor, we do stipulate and Mr. Grace does agree.
All right. Mr. Grace, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the nature of these proceedings?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And if you agree to enter this plea today, you will not get the opportunity for a trial in a court of law. You will not have the assistance of counsel to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you how do you plead to
I
criminal
plead guilty.
All right, and I'm assuming that's to criminal trespass causing damage to property. Would that be correct?
Yes, ma'am.
All right, just want to be sure you understand what you're pleading to. His sentence is 12 months to serve 32 days, credit for time served 16 days, balance suspended. You are to stay 200 yards away from Fellini's Pizza at 909 Ponce de Leon Avenue. That's the length of 2 football fields. So Please make sure that you do not return to the store, to its sidewalk, to its parking lot. Otherwise, they will have you arrested again. Thank you.
So what I decided now? I got,
So time served, you're out of here.
I transferred?
Yep.
I'm going home? I'm going home today.
So probably about 24 hours, so probably tomorrow morning, okay?
Okay, thanks. Thanks.
Thank you, Judge.
Thanks.
Next, we can go to position number 21 and 22, Jordan Harvey.
Deputy, we have a probation case today also, right? Marquez Wentz?
Yes,
Oh, okay, just want to be sure.
I was waiting for probation to get on.
Oh, okay. All right,
Your Honor, I'm here.
all right, thank you, Ms. Allen.
Okay,
This is State versus Jordan Harvey. Mr. Harvey has got a traffic matter under accusation 23 CR 7614B, in which he is accused of driving under the influence of alcohol, hit and run, improper passing of an emergency vehicle, unsafe vehicle or equipment, no proof of insurance, and possession of an open alcohol container. The second case is a bench warrant issued on, April 22nd, 2024. The original incident date is June 6, 2021. Ms. Vigiletti, how are we proceeding? I've got a not guilty and want to address the bench warrant. Is that how we're still proceeding?
Yes, Your Honor, that's how I would.
Oh, I'm so sorry, Mr. Dotis. Yeah, sorry about that.
We could be.
All right. All right. Your attorney is Mr. Dotis. And Mr. Dotis, are you filing a waiver of arraignment with regards to position 21?
Yes, Your Honor, I've filed that waiver and I'll submit it as soon as I leave the courtroom today.
All right. All right, you can proceed with the argument on the bench warrant, please.
Thank you, Your Honor. Mr. Harvey has this open case as well as another open case, 23 CR 002-885B, which is not on this calendar. He doesn't have any bench warrants for that. When I looked into the case and I spoke with Mr. Harvey, he had been reporting to all of his court dates and was in good standing on this other case. But for whatever reason, they're both in the same courtroom, but they weren't tracking together. Mr. Harvey did not understand, it was not clear, and it was not made clear to him that he had two separate cases. He has a good address, and he confirmed that he was getting mail for that other case, and he was going to the court dates for that case, but he was unaware of this case. No one was giving him any updates on this other case, and he did miss a court date. I would note that the incident date for this case was June 6, 2021. It wasn't accused until November 9th of 23. And then the following year was when, and of April this year was when he missed a court date. But like I said, he was going to all his other court dates for this other case. He just wasn't clear that he had this separate pending matter.
What court date did he have in the other case? He just had one.
Correct. In this separate open case from what he has an FTA on today.
Understood, but I'm curious to know what other court dates he just had a plea in arraignment and it was continued. So what other court dates were there?
He was present, Your Honor. I believe he was doing his monthly reporting and all of that. But when I spoke with him, it sounds like, I don't know if it was his attorney or someone with the court was giving him email correspondence on when to report for that separate court date, but they weren't giving him anything about this other case. So he was unaware of it at the time. He's clear that these are two separate matters now. He confirmed that the address in Odyssey is correct, and he can check his mail, Your Honor, and he's clear that he needs to report and do his best to check in once a month. So we would request this court set aside this bench warrant and give Mr. Harvey the chance to continue reporting for court.
I'm really confused. Let me ask, pretrial. Is this a pretrial services candidate?
I apologize. What was your question, Your Honor?
Is this defendant Jordan Harvey, position 21,
Mhm.
date of birth February 6, 1989. Is he a pretrial services client from November 9th, 2023?
Your Honor, it doesn't look like he is. I don't have any pretrial information on him. And even when I go to his his jailing screen, all I have is the FTA arrest from 2024. I don't even see the arrest from 2021 on here.
And Judge, I wish I had Mr. Harvey's phone so I could see. He said it's a Fulton County email address that was given.
I don't know what court appearances he made because he has on the prior case, 23 CR 002-885B, he had a plea and arraignment calendar on July 12th, 2023. And I'm assuming he made it for that one, but the case was continued. There's been no activity on that case since then. So one appearance, if I'm to accept that.
Yeah.
Then this current case, it was an accusation filed in November 9th, 2023. I'm assuming this is a bind-over case because he didn't attend first appearance in this court. So if he's been making appearances, it's been in a separate courthouse. And there was one scheduled appearance by Judge Porter on April 22nd, 2024. And let me check one thing, please. I don't see any mail being sent to him except in the current case, and that was returned to sender. And we have a Willow Trail Parkway, Norcross. Let me see his bind over. I
And
don't-
that, Your Honor, that was the correct address at one point in time, but he was, became residentially challenged, had to leave that address, which is why there was the return to sender. His
Okay,
address.
so that makes further sense then. I'm really perplexed by all these court dates that he apparently attended. Because as far as I can tell, there was only two. One he attended, one he did not.
And Your Honor, it may be an issue if it was bound over, he might have been reporting for another, or something else that I can't see a
All
record of, so
Okay, that makes sense then. All right, so what are you asking, Mr. Dotis, now that the world is set right for me, right? As far as I'm concerned.
Your Honor, I'm just asking the court to set aside this bench warrant now that Mr. Harvey is clear that all these cases are together in Fulton County, to give him the opportunity to come to court and address his matters at the appropriate times.
Okay, thank you. Mr. Hack?
The state is not opposed as long as he has a correct mailing address. It seems as though the last communication from the court was the return to sender, which means he may not have gotten notice about his last court date. So
All right,
based upon that, we have no objection as long as it's provided a current address too.
okay. On the position 21, oh, he's got a $3,000 surety bond right now. 2, 3, 4, 5, 6. Doesn't make sense. Okay, so on the bench warrant, I'm going to vacate and set aside. On the DUI case, on the charge of driving under the influence, that's $1,000. The hit and run is going to be $1,000. And the remaining 4 charges are going to be $250 each. That's a $3,000 signature bond through pretrial services level 1. Now he will be reporting to pretrial once a month. All right, Mr. Harvey, since you're very comfortable with reporting, please make sure you report to pretrial once a month. You are to maintain a current address with the courts at all times. If you change your address, if you become residentially challenged, you'll need to make sure that you let the court know so that we can make a accommodation to make sure that you get notice of your next court date. Any future misses and you'll be back in jail. But this time, from this moment onwards, you are to report to pretrial once a month, and you are not to consume any alcohol and no illegal drugs. You will be subject to random screens. Both your open cases with Fulton County are DUI matters. Thank you.
Thank you, Your Honor. And just to be clear, the address in Odyssey is correct for Mr. Harvey, but I do have a phone number to add so I can ensure that pretrial is in contact with him. Can I message that to Ms. Champion, or is there someone else I need to give that number to?
Yes, send that to Miss April Champion and also to Miss Tyson A, first initial A, as she's with pretrial services.
Thank you, Your Honor. I will do so.
All right. All right, this case and his and Mr. Doties, could you submit a waiver of arraignment for position of the other case, 23 CR 002
Yes, Your Honor. Will do so.
885B. So this will be an arraignment for both cases. And they will be scheduled for trial before Judge Porter.
Perfect. Thank you, Your Honor.
Next, we can go through the probation calendar, probation 1 and 2. Mr. Marcus Wentz.
Thank you.
More.
This is State versus Marquez Wentz, WENTZ, case number 24 PV 001026. This is a probation revocation matter with regards to the underlying case 21 CR 0032181, in which Mr. Wentz had been convicted of battery. Mr. Wentz, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Ms. Allen is with the Fulton County Probation Office. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. And Ms. Allen, what is the reason for the, when was he convicted, and what's the reason for the revocation, and what's the recommendation?
Your Honor, he was sentenced to probation December the 5th of 2022 for the charge of battery, where he was required to have no contact with the victim, complete 8 weeks of anger management, and stay away from the incident location. He has failed to provide our office with completion of the anger management course.
Has he reported?
Your Honor, I was actually reviewing that right now. It looks like he has missed, he came in one time. He came in as a walk-in, but he has missed all his online reports. Your Honor, it's 36 days remaining on his case. He has been in custody since June the 17th, 2024. Because of the time frame remaining on his case, probation at this time asks for his balance to be revoked.
All right. And all right, Mr. Dotis, go ahead.
Thank you, Your Honor. Mr. Wentz is 24 years old. He has been in custody for a total of 14 days at this time. When he entered the plea on December 5th, 2022, Mr. Wentz did enter that pro se. He was a little confused by the requirements after speaking with him yesterday. He wasn't too familiar with how probation worked or what was needed of him. After he did his one walk-in visit, he did tell me that he relocated to Augusta, where he currently now resides in Warrenton, Georgia. But he was confused on how to transfer his probation. He couldn't figure it out on his own, and he did the one thing he shouldn't have done. He made a mistake, and he just tried not to think about it and hoped it would go away. Your Honor, he is clear that he only has 36 days left. Given that he has served 14 days, Your Honor, we would request that he just be given time served and unsuccessfully close out his probation. If Your Honor is not inclined to do so, we'd ask that even though he has 36 days left, to modify his probation to allow him to do some sort of 1 day or 4 hour anger management course. And have a few weeks to try to knock that out on Zoom. So that he's not.
May I ask probation, where do we get the 14 days from? I have 9 days. Oh,
14 days. He's been in custody since June the 17th. I don't remember seeing.
June 17?
Yes.
Today is June
I
25th.
think the attorney said 14 days. I haven't done that.
Where's the additional 5 days from, Mr. Dodis?
It's from when he was initially booked. So let me look. Yeah, so Your Honor, this incident occurred July 4th.
I'm not including the time that he included, that he served before he was convicted. So we're
Okay.
not counting the time from 2022.
Understood. Well, Your Honor, I didn't mean to mislead the court.
No, I just wanted to be sure if
Okay.
so it is to serve 36 days and he's got credit for 9 days. So you're asking me to release him to continue on probation.
Your Honor, I am asking you to allow him to, yes, continue on, but modify. He of course doesn't have, I believe, time to do an 8-week program, but if Your Honor would allow him to do a 1-day anger awareness class or 4 hours of community or anger management that he could do online, Your Honor, I think that would serve Mr. Wentz better than any further time in the jail system.
Ms. Tyson, may I have Mr. Wentz GCIC since 2022?
One
He's
moment, Your
not
Honor.
done anything.
But if I let a cigarette out, the push sugars and blood, then what's going to turn me on? I didn't do nothing. I did something, but I didn't.
Let's see, 2022, looks like we have an arrest September 30th of 2022 in Warren County for forgery in the 4th, 2 counts of forgery in the 4th that resulted in a misdemeanor conviction. March of 2023. He has a October 12th of 2022 arrest out of East Point for aggravated, let me see, 2 counts of aggravated assault, 1 count of theft by taking, and 1 count of possession of firearm or knife during the commission of. Appears there's no disposition listed on the GCIC for that case. Let's see, we have 1 failure to appear, October of 2022 in Fulton County. We have a arrest out of East Point, March 27th of 2023, and that was for battery family violence in the first offense. A probation violation, June 6th of 2024 out of, it says Thompson Police Department. And a probation violation in Fulton County, June of 2024 also.
This one. All right. Anything else, Mr. Dodis?
I would just point out that, Your Honor, it looks like this was his first case that he had probation. It seems like some of these later incidents happened and the only conviction I can see was for the forgery in 2022.
Okay. I'm going to revoke the balance, give him credit for 9 days, and he's gonna have to serve out the rest of the time at the Fulton County Jail. After that, this case is closed and his obligations are completed. Thank you.
Thank you, Judge.
Thank you, Judge. That concludes my business, Your Honor. May I be excused?
Yes, thank you.
Thank you.
Wait a minute. Deputy Sir.
Next case, please.
I can speak with them.
Next, we can go to position number 31 to 32, Mr. Maurice Lee. I need to talk. Just it.
All right, Mr. Maurice Leaks is case 18 CR 840F, accused of driving without a valid license and expired or no registration and failure to maintain lane from April 30th, 2016. And he's got a bench warrant from November 15th, 2023. Mr. Leaks, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, unfortunately, most of your entries on the cheat sheet don't tell me how you're moving on. So how are we moving on?
Your Honor, I actually do need to speak to Mr. Leaks briefly. I got some documentation of what he thought was taking place, and we just need to talk very quickly.
All right, I'll take another case then while you are talking. Mr. Dotis, do you have any other cases to address in courtroom 2?
Yeah, Olivia, can we go home to the back? Yeah. No, Your Honor, the rest of mine are at ACDC, I believe.
Oh. ACDC, are you ready?
We could just go to another position. We can go to position number 33 through 35.
All right. Ms. Vigiletti, are you ready to address Jimmy McKinnon?
Yes, Your Honor.
Okay.
And
how are we proceeding on Mr. McKinnon?
Mr. McKinnon would like to enter a not guilty plea, Your Honor, this morning, and I also have a bond request.
All right. On Jimmy McKinnon, let's begin with position 33. Mr. McKinnon, first of all, please remember that you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. With regards to your 4 open cases, you have 23 CR 4835C, in which you're accused of simple battery family violence and simple battery against a person who is 65 or older or who is pregnant from October 10th, 2022. You've got a second case for criminal trespass under 24 CR 996C from March 2nd, 2024. You've got a third case for simple battery, family violence, and terroristic threats and acts under 24 CR 3688C from April 13th, 2024. And you have, did I miss one?
I believe it's just 3 cases, Your Honor.
Oh, okay, I'm sorry, it was 3 cases. Yeah. So these are the 3 cases, and are you filing a waiver of arraignment, and or would you like me to arraign the cases?
I'll file a waiver.
All right. So positions 33, 34, and 35 are going to be further notice for trial. All right, Ms. Vigiletti, you may proceed with the bond modification request.
Thank you, Judge. I believe Your Honor set Mr. McKinnon's bond when he came to the jail 2 weeks ago. Currently, he has 2 cash bonds. The terroristic threats and acts is set at $1,000. The simple battery family violence is set at $1,500. There is also a $3,000 surety bond on the criminal trespass. And I'm asking Your Honor to consider converting all bonds to surety bonds this morning, so his family has some chance to bond him out. Whereas things are set right now, as you're aware, they would have to pay roughly $3,000 to get him out, and his family doesn't have it. Your Honor, I believe this is the most family support I have ever had someone display. I have had discussions with multiple people yesterday, family and friends, just speaking on Mr. McKinnon's behalf. They tell me that he was working at Popeyes and had actually just also gotten a second job at KFC, was doing quite well. He had taken first offender status, as you know, on a case from last September, doing well on his first offender. He's been checking in and doing what he's supposed to be doing for that. Mr. McKinnon tells me he's never missed court. He's really trying to be on the right path here. He staunchly denies any allegations against him regarding Ms. Houston. I have had multiple people reach out to me telling me that she's telling them that she wants to have him killed and sort of bragging about getting him into trouble. It sounds like there is perhaps an alternative story here. He does have a child on the way with another woman, and it sounds like perhaps there is some retaliatory feelings happening in this situation. Mr. McKinnon is well aware of stay away from her. He has been attempting to comply with that. His mother, who I believe is here, has been doing the third-party transport of the children. He is happy to continue to stay away from her or comply with any terms of bond that you would be willing to set. I mean, he just really wants to get back to work, stay on track. Of course, he has every incentive to show up for court because this case does risk violating his first offender status. So I don't think we have any more concerns here that he might not show up for court. He does have stable contact information. And so, you know, if Your Honor is willing to consider a surety bond, it sounds like his family and his community are willing to help him get out and get back to work.
All right. Who do you, I have a young lady over here on iPhone 6. Is that someone related to this case?
I believe so, Judge.
All right, ma'am, what's your name, please?
I'm the mother.
Raise your right hand, please.
I'm
Do you
sorry,
solemn-
Your Honor.
Raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
And what's your name, please?
Shantae McKinnon.
Right. And
My phone's like kind of breaking up, so I can barely hear you guys.
what would you like to tell us?
I'm trying to, all this stuff that's been going on with my son, it's been like fake organization against him. And he's trying to move forward, but he can't move forward because he got someone that keep on lying on him and stuff like that. She know that he's on probation, so she do anything that she can to, you know what I'm saying, get him locked up and get him hindered.
Okay. Just 1 second, please. This person who's on iPhone 1, you'll need to start your video. Otherwise, I'll remove you from Zoom. All right.
Well, while we're waiting, may I ask Ms. McKinnon a couple of questions?
Hang on. Who is this person? Is this iPhone 1?
This is me, but I'm finna leave. I can't do this.
Who are you? Okay, I have no idea who that person is. Okay, go ahead, Miss.
That was the girl.
All right.
That was the girl.
Okay, thank you. Anything else?
Ms. McKinnon, would you be willing to help your son Jimmy make sure he comes to future court dates?
Yes, I will.
And have you been facilitating the third-party transfer of his children?
I mean, I can, but I'm trying to do everything by court order. I need to be everything by handled by court order.
There is no third-party transfer. He's not supposed to have any contact with children that he shares with Miss Houston. So I'm a little perplexed by that question.
Oh, I'm sorry, this must be my mistake.
Judge, Miss Houston just came on the line. I guess she's a victim in the case.
Yes, she is.
My bad. I'm at the doctor.
All right, Miss Houston, I will let you speak very shortly, but please remain silent. Thank you. All right, your next question, Miss Micheletti?
Yes, just to clarify my mistake here. Ms. McKinnon, when you said you went to pick up the children in the past when we talked yesterday, was that just for you to have time with them?
No, she dropped the kids off, but I was telling her that I have to have everything got to be ordered by court. She had to wait until we get everything situated, but she was demanding him to get the kids and stuff like that.
Okay,
So-
okay, understood. So you're trying to just facilitate, make sure he's staying compliant with his court order.
Yes,
Got it.
yes.
Who dropped what kids off? That's my question.
Miss Houston, last time, I'm going to say this. You need to remain silent until I say you can speak. All right. Anything else, Ms. Micheletti?
I don't believe so, Your Honor.
All right, Ms. McKinnon, do you have anything else to add?
Not at this time, Your Honor.
All right, please mute your screen. Ms.
Yes, ma'am.
Natara Houston, if you would like to address the court, you have to start your video, unmute, and I need your video in front of your camera in front of your face. Lower the device. Lower the device. Remove your hat.
I can't right now.
Lower your device and remove your hat. Now, I can't hear you.
She says she's in the hospital.
She's where?
I have to join back.
She indicated she's in the hospital.
In the hospital. Okay, then I need to
I'm at the doctor's office.
lower your device so we can see your face. All right. What would you like to tell the court?
I just heard too many lies.
All right. Are you dropping off your children with Miss McKinnon?
No,
You are not supposed to. So anything else you
I
want to
haven't.
tell me?
She haven't been around my kids since last year.
Okay. Anything else?
No.
All right. Thank you. You can mute your screen. Thank you. Miss Mokeke, what would you like to say?
We believe that the bond amounts are appropriate as is. Position 33 involved Ms. Natara Houston, and then position 35 also involves her. And in his simple battery case from 2022, I think he was ordered to have no further contact with the victim. Those were part of his bond conditions. So in seeing her on April 13th, 2024, he violated those bond conditions and then punched her in the head and then was sending her text messages saying that he was going to shoot her in the face. He also looks like he has a 2023 aggravated assault, battery, family violence, and possession of a knife or firearm during the commission of a crime. And it appears as though Ms. Houston was the victim in that case as well. So these are now 3 cases that involve Ms. Houston. And so the state believes that his bond is appropriate as is.
And Your Honor, if I may, I just want to reiterate that Mr. McKinnon states they did not have an interaction at all on April 13th, did not violate his no contact order, and multiple friends and relatives have reached out to me to tell me that she does have access to his accounts and has been sending messages as if she is him. That is.
Okay. So Miss Vigilante, you know that raises an issue of fact that needs to be resolved at trial.
Absolutely, Your Honor.
My concern is that I have 3 open state court cases, and I have a and you're right, he does have a Superior Court matter also involving a violence issue, which is under first offender status.
Yes, Judge.
And they all involve violence. They all allegedly involve domestic violence. And any issues about he said, she said, what the victim allegedly claims outside to other people, those are all issues of veracity that must be resolved at trial. My concern is under Ayala factors is whether he poses an alleged threat to the victim and whether he poses a threat to reoffend. And the bond reflects that. The bond modification is denied, and this case is going to go to trial, along with his 2 other cases.
Understood. Thank you, Your Honor.
Thank you. Thank you, Ms. McKinnon. You're free to go.
Next, Your Honor, we're gonna go to position number 40, Mr. Corey Smith. Yes.
This is State versus Corey Joe Smith, accused of willful obstruction of an officer from May 4th, 2023, under case number 23 CR 2804H. Mr. Smith, you also have a bench warrant under 24 FTA 757 from June 17, 2024. You've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Your Honor, I have sent yourself, Ms. Champion, and the state an email providing proof of Mr. Smith's incarceration at the time that he failed to appear for court. So we're just requesting that that warrant be lifted this morning.
All right. Ms. McKechnie, have you received that email?
I have received the email. It does look like he's been incarcerated since August of 2023, so we would have no objection.
All right, we're going to set aside the bench warrant and vacate that. Could you please submit a proposed order, Ms. Vigiletti?
Yes, of course, Your Honor.
All right. And Mr. Smith, we're going to arraign your case on the misdemeanor obstruction. Do you submit a waiver of arraignment? Shall I arraign him?
I'm happy to file a waiver, Your Honor.
All right. Mr. Smith, your attorney, Ms. Vigiletti, is submitting a not guilty plea on the willful obstruction. Your case is now going to be further noticed for trial. Please make sure that your mailing address is current with the courts at all times. If you are unfortunately detained, whether it's in a hospital or in another facility, it is actually your responsibility to make sure that you get information to your defense attorney or to the court that the reasons why you're unable to make it to your next court date. Otherwise, unfortunately, you will be arrested and we would have to address it in this manner. Thank you.
Thank you.
Next, Your Honor, we got a position, this way, Mr. Stone. We have position number 42, Mr. Spencer.
All right. Devontae Spencer is accused of battery, family violence from April 2nd, 2024 under accusation 24 CR 3674Y. You've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. How are we proceeding, Ms. Vigiletti?
Your Honor, Mr. Spencer would like to enter a not guilty plea this morning. He did also inform me that he will have a private attorney joining this case shortly, and so I am going to reserve the bond argument for that attorney when they come on. So,
Mr. Spencer, what is your attorney's name?
Mr. Jackson.
Majeski?
Yes, he's in murder trial in I think Washington County.
All right. If you're planning to enter a not guilty plea, I am going to only do this with your attorney present, so I can reset the, hang on, let me check. Entry appearance. Oh, Mr. Majeski entered an appearance on June 24th, 2024. So he entered representation for you yesterday. And he also filed a waiver of arraignment and entered a not guilty plea on your behalf. So your case is going to be further noticed for trial.
All right, thank you, Your Honor.
So this case has already been arraigned, and a waiver of arraignment, and it's going to be further noticed for trial. Thank you. Who do we have next?
Position 45 and 46, Mr. Whitaker.
All right. This is Jerome, excuse me. Well, I have two different names, but Jerome Dexter Whitaker is accused of criminal trespass and causing damage to property from March 5th, 2022. You said 45 and 46?
Yes.
And 46 is a bench warrant for 24 FTA 758 from April 12th, 2023. Mr. Whitaker, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Mr. Whitaker would like to enter a negotiated plea this morning, Your Honor.
All right. So if you raise your right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Mulcahy?
Yes, Your Honor. The recommendation is 12 months probation, served 24 days, credit for time served 12 days, balance suspended, stay away from all MARTA locations, and the state will be null crossing the FTA.
Ms. Vagiletti, do you enter the appropriate stipulations?
We do, Your Honor.
All right. Mr. Whitaker, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's been going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes.
And you understand that once I accept your plea, you cannot return to the MARTA locations, especially if you've got any suspensions against you.
Yes, Your Honor.
Okay. And if you decide to plead guilty, you will not get a trial. You will not go back to court with your attorney to confront your accuser, challenge the evidence brought against you, present your own arguments and defenses, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to criminal trespass causing damage to property?
Guilty.
Your sentence is going to be 12 months to serve 24 days, credit for time served 12 days. Your jail time is concluded, the balance is suspended. However, you cannot return to any MARTA bus station and any MARTA train station as long as there are any active suspensions against you. If you return to a MARTA station or you are on a bus or a MARTA train, you will be arrested and brought back to jail. Thank you.
All right.
Next, we can go to position number 47, Mr. Reginald Wilbur.
All right. Mr. Whitaker's bench warrant is null crossed.
Thank you, Your Honor.
Reginald Wilburn is accused of willful obstruction of a officer from March 4th, 2024, case 24 CR 1020G. Mr. Wilburn, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Mr. Wilbur would like to enter a not guilty plea this morning, Your Honor. I am happy to file a waiver of his arraignment.
All right, Mr. Wilburn, your attorney will be entering a not guilty plea on your behalf pursuant to the waiver of arraignment, and the case is further noticed for trial. Anything else?
No, Your Honor. Thank you.
That concludes this matter.
We could go to position 48, Mr. Javaris Woodard.
ACDC will be with you shortly. Jarvis Jermaine Woodard is accused of criminal trespass, simple battery against an officer and public indecency from June 9th, 2024, case number 24 CR 3594E. Mr. Woodard, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Your Honor, Mr. Woodard would like to enter a not guilty plea this morning, and we have a bond request.
All right. Will you be filing a waiver, or shall I arraign the case?
I can file a waiver, Judge.
All right. Mr. Woodard, your attorney is going to submit a waiver of arraignment and enter a not guilty plea on your behalf. And you may proceed with your bond argument, Ms. Vigiletti.
Thank you, Judge. So Mr. Woodard does acknowledge that he was at MARTA when he had previously been trespassed. The source of the issue is, as you can imagine, Your Honor, homelessness. Mr. Woodard has spoken to both myself and our social worker, Kia Burgess, and we have all agreed that it would be a good idea for him to go to Atlanta City Baptist Rescue Mission. He's particularly interested in the classes they offer, and that church is part of the program. It is a 60-day program. And so if Your Honor is willing to convert his bond to a signature bond, that is where he would like to be. He does deny ever biting the officer and does want an opportunity to plead his case and fight those charges. This program, it's my understanding, in those 60 days do help with long-term housing, which is what he needs. He does have a stable address he can provide the court. He takes part in Crossroads Address Program, so he can use the 420 Portland address that homeless people often use to receive mail. And we've discussed checking that very regularly. So if your honor is willing to consider bonding him out to this program, I think it would be a great opportunity for him.
All right, Ms. Mokeke?
Given the defendant does have 30 arrest cycles and he does have a 2023 conviction for a simple battery. So given that, the state's recommendation is that the bond stays the way that it is.
The bond presently is a $2,000 surety bond. And I do understand his concession with regards to the Mata incident. My concern is he was booked into, and I don't know if I'm repeating myself because I'm sure I must have addressed this at first appearance. May 25th, 2023, he was booked in on theft by taking and willful obstruction, released 2 days later on a UJR. September 21st, 2023, he was booked in again in Fulton County Jail on robbery, trespass, criminal damage to property, and there was a time served on the trespass as well as a separate charge. December 31st, 2023, this is his third arrest. Theft by taking, signature bond. 3 months later, he's booked into Fulton County Jail again on March 2nd, 2024. Again, robbery, terroristic threats, and 2 counts for willful obstruction, which was subsequently dismissed, and he took a time served on the theft by taking. He was released on April 17th, 2024. Less than 2 months later, he's back at the Fulton County Jail. Ms. Vigiletti, this is not a symptom of just homelessness. This is a symptom of recidivism.
I'm sorry.
And the bond is very, very reflective of Mr. Woodard's incredible likelihood to reoffend.
I completely understand your concerns, Your Honor. He has been living on the street and has picked up a number of cases. Would it help, Your Honor, to feel more comfortable if our office was willing to transport him directly to the program?
It's not the housing, Ms. Vigiletti. We either have an MH or a BH issue.
Understood, Your Honor.
Nothing that would assure the court that under yellow factors that simply because Mr. Woodard's placed in housing that he would not reoffend.
Understood, Judge.
Bond modifications denied. This case is further notice for trial.
So when I go back to court.
Next, we could go to position, oh, 1 second, Your Honor. Can we have a moment, Your Honor, so Ms. Vigiletti can talk to her client?
Sure.
Your Honor, we can go to position number 38, Mr. Chad Murray.
Okay. All right, Miss Vigilante, are we still asking for the 1 week reset for Mr. Murray?
Your Honor, I did receive yesterday evening an acceptance letter into PAD for Mr. Murray. I did send that to Ms. Falk and I've just forwarded that to Ms. Mokeke and Mr. Ham. I am wondering if, considering his acceptance into PAD, if the state would be willing to divert the case, but I'm also sensitive to the fact that the plea offer doesn't ask for additional jail time. Is it possible, if the state is not kind of prepared to move forward on the question of diversion today, to reset it to Thursday so that, you know, we're not keeping him in jail for a bunch of additional time?
I will see the case on Thursday. We can put it as an add-on.
Thank you, Your Honor.
Position 38 is reset to June 27th.
Thank you, Your Honor.
Position number 43 and 44, Strozier.
Ms. Vigilante, how are we proceeding on Mr. Strozier?
Your Honor, Mr. Strozier would like to enter a not guilty plea this morning. He does waive his arraignment, but wanted to be present this morning.
All right. Maurice, is that the gentleman at medical?
It is.
All right. Mr. Maurice DeAndre Strozier, my name is Judge Law. We are addressing your cases this morning, 21 CR 1959Y, in which you're accused of simple battery, family violence, and reckless conduct. And the second case is a bench warrant from December 13th, 2022, 24 FTA 722. Mr. Strozier, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigilante. Ms. Vigilante has entered a waiver of arraignment and a not guilty plea on your behalf. So your case is going to be further notice for trial. In the meantime, your attorney would like your bond to be reconsidered. Ms. Vigilante?
Your Honor, I wasn't intending to make a bond request this morning.
Oh, I'm so sorry. What were you going to ask then? I'm so sorry.
He just wanted to be present, Your Honor. He has a hold on a felony case, and so the bond isn't, it doesn't need to be addressed on any short timeline. His next felony hearing is August 16th. So we expected we'd make a bond argument closer to that time.
All right. Then both his cases are further notice for trial. Thank you.
Thank you, Judge.
Next, we have position 7 and 8, Ms. Beard.
This is State versus Latasha D. Beard. Case number 22 CR 7619E, in which she's accused of theft by taking from June 14th, 2020. She has a bench warrant for under 24 FTA 737. Ms. Beard, you've been advised of your right to remain silent, and your attorney is Mr. Dodis. May I place you under oath, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Mr. Ham, what's the state's recommendation?
Yes, Your Honor. State's recommendation for position 8 is 12 months to serve 28 days, credit for the time served, 14 days, balance to be served on probation, to stay away from the Dunkin' Donuts located at 6060 Old National Highway, to complete 40 hours of community service, and to take an anti-theft course. As it relates to position 7, the state will move to null prostate count.
Mr. Dodis, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, and we do so stipulate to the factual basis, venue, and ID for the purpose of this plea.
Ms. Beard, have you consumed any medicine or alcohol recently?
Sure.
You need to speak up, please.
No, I have not.
Thank you. And have you understood what's going on in your case?
Yes, I do.
And are you satisfied with your attorney?
Yes, I am.
Is anyone forcing you to plead guilty to this charge today?
No, ma'am.
Because if you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not return to court with your attorney to confront your accuser, challenge the evidence brought against you, be able to present your defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking?
Yes, ma'am.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. If you have no other holds at the jail, you will be released within 24 hours. You must report to the Fulton County Probation this Thursday, June 27th, before 3 p.m.
Okay, will this be unsupervised or supervised?
This will be supervised probation.
And Your Honor, I think when I spoke with Ms. Beard, I did say I would request if this court could waive a few months of her probation fee so she can get back on her feet upon release and allow suspicion of non-reporting status upon completion of all conditions.
All right. Let me first go through a couple of things. She'll be reporting to the Fulton County Probation this Thursday, June 27th, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta, and she must report there before 3 p.m. Mr. Ham, any objection to, excuse me, non-reporting after she has completed all her conditions and she's up to date with her probation fees?
No objection, Your Honor.
All right. And Mr. Dotis, let me see, 1978, okay. I can waive the probation fees up to and including through August, is it 31st or 30th? I can never remember those dates.
Wow. I was gonna defer to you, Judge. Put me on the
Oh,
spot.
shoot, okay. Well, they do that little trick with their hand, but I never do that.
It's 31 days in August.
31 days, thank you, Mr. Ham. All right. I will waive probation fees for the months of July and August. And then she would need to start paying probation fees from September 1st onwards. Ms. Beard, you will be on supervised or what we call reporting probation. While you're on probation, you need to complete 40 hours, that's 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. So you can do your community service at agencies like Goodwill, the Food Bank, Animal Rescue, Salvation Army, but not at a church or a school. And you must complete a minimum of 5 hours per month while you're reporting to probation. You're also to enroll in an anti-theft class within 45 days of being released, and you must complete that class before you're considered for non-reporting probation.
Yes,
That
ma'am.
concludes your sentence. Thank you.
Thank you.
Oh, and of course, stay away from the Dunkin' Donuts at 6060 Old National Highway.
All right, thank you. Next is position 13.
All right, and Mr. Dotis, her bench warrant is null crossed.
Thank you, Judge.
Position 13 and 14, Elsner.
Right. This is Christy Elsner. The first case, 22 CR 690C, involves two offenses: discharging a firearm on property of another and reckless conduct from February 11th, 2022. The second matter is a bench warrant 24 FTA 750 from October 14, 2022. Ms. Elsner, you've been advised of your right to remain silent, and your attorney is Mr. Dotis. Mr. Dotis, how would you like to address this matter?
Yes, Your Honor. Ms. Elsner will be entering a plea of not guilty, and I'm going to file a waiver of arraignment at the close of business or court today.
Okay.
And we would ask to address the position 14 bench warrant.
You may go ahead.
Thank you, Your Honor. Ms. Elsner did miss court on October 14th, 2022. At the time, her mom passed away and she was struggling greatly during this period. She didn't intentionally miss court. It slipped her mind with the pile of everything going on with her personal life. When I spoke with Ms. Elsner, she informed me that as soon as she became aware of the bench warrant and the failure to appear, that she voluntarily turned herself in. Your Honor, she's clear that moving forward, she needs to make sure that she's communicating even if there are these personal issues. But she didn't miss any other court dates except for this one in October. So she would ask for a chance to make that right and have this bench warrant set aside and make it to all of her future court dates.
All right. Mr. Hebb?
We actually are opposed to that. It seems as though when she was in court, she was instructed to obtain a public defender or pay the application fee to get a public defender. That happened on August 30th, 2022 on a status conference. The case was reset so that she can pay the application fee. Prior to that, it was reset again because of a family emergency on July 27th, 2022. And then when it came time for the jury trial calendar, that's when this defendant failed to appear when it was set down for trial. She still had not paid to receive that application fee for the public defender. And the court noted that several times that it was reset so that this can happen. So it seems as if she didn't comply. She didn't have an attorney on the actual trial date for the jury trial, and she just did not show up. So based upon that, Your Honor, we would ask that the bench warrant status stays in place.
Mr. Doris, any rebuttal? Looks like the state believes there's a different reason for her failure to appear.
Your Honor, when speaking with Ms. Elsner, I understand that her mom was suffering for a while, which I do see that reset back in July. And then she did tell me that her mom did pass later that year. Again, I do see the notes about no PD application received on Odyssey. After speaking with Ms. Elsner, this was just a very traumatic period, and she wasn't giving this court case the attention it needed in the wake of dealing with her family issues. Moving forward, Your Honor, she will have now that she's in custody, she will qualify. She will be granted a public defender who will have her contact information, and we're going to make sure that we work with Ms. Elsner so that all her personal and court issues are taken care of, and she's doing what she needs to do to appear moving forward.
So am I assuming that she has completed her application?
Your Honor, at this point in time, based on the fact that she is in custody and cannot pay the bond on the FTA, after speaking with her, she will qualify, and we will have an attorney file an entry.
Okay, I'm going to modify the bond to $1,000. It's a surety bond. No firearms, no weapons. And same conditions apply. No contact with Yukari De La Cruz and stay away from 501 Connell Avenue in Atlanta, Georgia.
And so, Your Honor, is this a $1,000 surety bond on the FTA now, or how does this?
She bonds out. And then
I just want to make sure I'm entering the order correctly.
yeah,
Okay.
her bond on the FTA is amended to $1,000 surety. She already made bond on the original charge, on the original charges. She's got a $1,000 surety bond on the failure to appear. So once she makes the $1,000 surety bond, she'll be released. She'll need to make sure she has no contact with Yukari De La Cruz. Stay away from 501 Connell Avenue in Atlanta, Georgia. She's not allowed to own, possess, or have any firearms on her person, in her home, or anywhere near her. She must make sure that if she intends to have the public defender's office represent her, a condition of the bond is that she must complete the application for the public defender's office before she is released from the Fulton County Jail.
Okay, so how do we provide proof of that? She's already applied through our interview, and we've we would accept her.
Mr. Doris, if you tell the jail that she's already completed the application, they will take your word for it.
Oh, Your Honor, I just want to make sure that I'm doing what's asked.
All right. Mr. Angelo Doris tells the jail that she has completed the application and that's good enough for the court.
Thank you, Your Honor. And Your Honor, if with Miss Elsner there, if Officer Milton is there, if I could have ACDC give me a call at that courtroom too, so I can speak to Miss Elsner.
Okay,
Copy that.
thank you.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Next
Thank
case,
you so
please.
much.
I have positions 36 and 37, Mr. Muhammad.
All right. 36 and 37. Is that the gentleman at jail call?
Yes.
Okay. And are you Mr. Jamal Muhammad? Mr. Muhammad, could you please say yes or no? Are you Jamal Muhammad?
Yes, ma'am. Good morning. Good morning, Your Honor.
Are you Mr. Jamal Muhammad? Is that
Sir.
your name?
Yes, ma'am.
All right, thank you. Mr. Muhammad, your case number is 24 CR 877H, in which you are accused of simple battery family violence from January 30th, 2024. You have a separate case, 24 CR 3710H. And in that case, you are accused of battery at a public transit vehicle or station. 2 counts. A second count for simple battery at a public transit vehicle or station, and a third count of criminal trespass.
Yes,
And this is from April 25th, 2024. With respect to both cases, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. Ms. Vigiletti, how are we moving forward with these cases?
Your Honor, Mr. Muhammad would like to enter a not guilty plea, and I do have a bond request.
Okay. And you're submitting a waiver of arraignment, or do I arraign the case?
I'm happy to submit a waiver, Your Honor.
All right. In both cases, Mr. Muhammad, your attorney is entering a not guilty plea on your behalf, and your cases are going to be further noticed for trial. All right. And tell me, what is his bond in each case at the present time?
His bond only applies to the case from April 25th, Your Honor, and it is currently a $4,000 surety bond.
Okay. You may proceed.
So I spoke with Mr. Muhammad as well as his family and a friend who I believe may be here today. Her name is Alexis Fields, who's willing to speak on his behalf. And he does have a stable place where he can receive mail, and he does have a phone number. So, you know, keeping up with the court shouldn't be a problem. I spoke with his grandmother who, although this bond request is not related to her case, there is a case open involving her, and I do think how he's behaved in that case will be instructive for how he will behave in this case. I spoke with her. She said, you know, her intention when she called the police was for him to move out of the house, which he did, and that he's been completely compliant ever since with that order, and so she's had no further issues. So I think that's good evidence in this case. I did speak to Mr. Muhammad about the incident, and he has absolutely no problem staying away from the 2 alleged victims, although, you know, he does have factual contentions. He does deny the allegations. He has absolutely no problem complying with the stay away or any other considerations. Mr. Muhammad is from Atlanta. Like I said, I have talked to multiple people who are willing to be supportive, help make sure he comes to court. And so I don't think we'll have any problem, Your Honor, with Mr. Muhammad coming to court or having a further incident with Ms. Morgan or Ms. Diallo. We are requesting a bond today in part because He was fired the day he was arrested from his job. Of course, it's difficult to keep a job when you're in custody. He does want to get back to work. He wants to get out and do some job seeking. We discussed possibly a few hotel restaurants that he might work at. And in the interim, he knows of a temp agency he wants to get started working with, Your Honor. And so, you know, while he is fighting this case, as you're aware, that can take significant time, and his time would be better served, and really everyone's time would be better served if he was, you know, working and participating in his family.
He was released from you said the simple battery charge involving excuse me, let me get this. Involving Connie Mabry. Is that the individual?
Your Honor, yes, that's his grandmother, and so he's not being held on that, but I did just bring it up just to say, when I spoke to Ms. Mabry, you know, her intention when she called the police was for him to move out, and he has been very compliant in that case. They've had no further incidents, and he's moved out and has been compliant with the no contact.
He's still got her address. He's required to stay away from that address.
He has been a bit transient, Your Honor, but I do have a stable address I can provide the court for him. A friend has offered her address for him to use. He has been staying with his cousin, and his cousin is moving, and so he didn't want to provide the court that address, and then it's a bad address. But I do have a mailing address for him here. I'm happy to put it in the chat.
All right. Ms. Mukiki?
Yes, Your Honor. In regards to position 37, the defendant is accused of punching Nakia Morgan in her arms and face while they were on the southbound platform of the North Avenue MARTA station. The assault did leave a knot on Ms. Morgan's eye, and the defendant also tried to spit on her. The same day, the defendant is also accused of spitting on a second victim, Ms. Aminata Diallo. The incidents were captured on CCTV footage, and the defendant had received a permanent ban from all MARTA stations on, looks like May 4th, 2024. The defendant does have 19 arrest cycles. It looks like he has a conviction for battery and willful obstruction from 2022, a 2021 simple battery where he pled nolo, 2018 simple battery family violence. There are 2 counts, a 2018 simple battery and criminal trespass.
I'm familiar with all 19 cycles, Ms. Mukiki. Thank you.
Yes, Your Honor. So just given the defendant's history and the facts of this particular incident, the state does believe that the bond amount is appropriate.
Bond modifications denied. The case is further notice for trial.
Understood, Your Honor. Thank you.
Mr. Mohammed, your case is going to be your cases are going to be further notice for trial, and your bond currently stands at 4,500 surety. Thank you.
Thank you.
Next case, please.
We can go back to position number 48, Mr. Woodard.
This is Mr. Leaks.
Oh, Leaks. My mistakes, Your Honor. Position 31 and 32.
31 and 32. All right. And I just received an email from Ms. Vigiletti with regards to this case. All right.
Yes, Your Honor, and it appears one of the photos I attached did not attach correctly, so I'm resending it.
Okay. All right. Mr. Maurice Leaks' case is 18 CR 840F, in which he's accused of driving without a valid license, an expired or no registration, and failure to maintain lane. And and this is from April of 2016. And he's got a bench warrant, 24 FTA 755, failure to appear on November 15, 2023. Mr. Leaks, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. And Ms. Vigiletti, how are we proceeding on this matter?
Your Honor, we'd like to make a bond request this morning based on Mr. Leake's belief that this case has already been resolved. I attached some documentation, not of the case actually being resolved. There are two documents that his sister shared with me. One of them you can see is proof of a dismissal of a separate driving case, and one of them is proof of his bond on this current case. Mr. Leaks tells me that he does also have proof of a dismissal of this case. He has been working very diligently on his driving offenses because he is working on getting his license reinstated. So he actually has been going to court dates with City of Atlanta to get his license reinstated and get all of this traffic stuff worked out. And so it's my understanding that the last time he was bonded out on this issue, he went straight to the court, straight to the clerk's office, got all the paperwork of his prior cases, got proof, he tells me proof of dismissal of this case, and got his license and is working on getting his license reinstated. I think either one of two things is happening here. Either Mr. Leaks is misunderstanding, and perhaps the documentation of the other case is what he's remembering, which is a reasonable mistake, or he does have proof of this case being dismissed, at which point, of course, it would be very important to be able to present that to the court. So we are asking for the failure to appear to be lifted this morning, Your Honor. We have a good address in for him now. I can't see where the court sent his previous address, the previous mail that was returned to sender, but he didn't get notice of this court date and did believe earnestly that this was resolved.
What is his current address now?
Your Honor, it's correct in Odyssey. I don't necessarily want to read his.
The Forest Hills Drive?
Yes, that
Okay.
is correct. And that was, as you can see, just updated 10 days ago. So
Okay.
that's his address. He can receive mail there. He certainly wasn't missing court on purpose, did not receive notice of this. And as I've said,
I don't know why he did not receive notice, and there is no dismissal of this case. Judge Eric Richardson has never dismissed these traffic charges. If you went to City of Atlanta and you had these charges dismissed, that would be incorrect, because City of Atlanta does not have jurisdiction over this case since it was bound over to the State Court of Fulton County. So let me be very clear on the record that's being recorded. These traffic charges are not, N-O-T, not dismissed. They are open, active against you. Do you understand, Mr. Leaks? Mr. Leaks, do you understand?
No, not really understand that what you is saying that now, ma'am.
These traffic charges are not dismissed. This is an open, active case against you. Your bench warrant is amended to a 2,000 signature bond through the jail. This case has been arraigned. Let me make sure. No, it's not been arraigned because he's never shown up for court. Would you like to file a waiver of arraignment, Ms. Vigiletti?
I'm sorry, Judge, we just had a computer issue. Yes, I'm happy to file a waiver and a modification of the bond, Your Honor.
This is an open, active traffic case against Mr. Leaks. It has never been dismissed. I don't know what he did in City Court of Atlanta. City Court of Atlanta does not have jurisdiction over this case. We have an active case against Mr. Leaks. I can keep repeating till a brown cow comes home, but I'm just letting you know right now. Not dismissed, okay? I hear this from traffic court all the time. And folks, once a case comes to state court, city court has no jurisdiction to dismiss the case. Now, he has a, what did I say, 2,000 signature bond through the jail?
Yes, Judge.
These are his only obligations. Make sure his address is current with the court at all time. He is not allowed to drive unless he's got a valid driver's license attached to his person, adequate insurance, and proper registration for the vehicle that he drives. and he must report to court at all times when summoned. If he's not sure, he can contact the public defender's office or come by and visit the court every week to make sure that he's got a court date and that he's not going to miss it. And that would be the Fulton County State Court, not the city court.
Do they have a number that we can keep calling?
Yes, I'll provide you with all of that.
Yes, ma'am.
All right, thank you, Your Honor.
Mhm.
And
Next,
Judge,
case, please.
that does conclude everyone that's here in the courtroom. I believe we're just waiting on the jail phone, the jail court iPhone to bring the next client.
Okay, let me just go down the calendar then. On the probation revocation matter, the probation was revoked for Mr. Wentz. He's got a few more days to serve out his time before the case is closed. On the add-on, Michael Hall, what are we doing in that case?
Your Honor, that is a reset from the 11 a.m. calendar, and we haven't gotten a recommendation yet from the state on that case.
Do you want me to reset it?
Yes, Your Honor.
All right, so this is going to be reset to the July 2nd. Is that July 2nd next week?
Yes, Judge.
Yes, ma'am. Okay. And then position 2, have you spoken to your client?
I have made a couple of attempts. I have not been successful yet. If they're able to, he's on 3 North, Your Honor. So if they're able to get him today, I'm happy to speak to him. His plea offer would get him out of jail today. So I'm hopeful that they're able to get him to speak to me.
All right, we had him reset from June 18th. And now we are on June 25th. So if I do a 1 more week reset, he has to decide what he wants to do.
Okay.
Are y'all planning to have a social worker visit him?
Yes, absolutely. I feel speak to them. That the issue has been him not wanting to speak to anyone.
July 2nd, he better come out and have a little talk with us, okay?
Okay, Your Honor.
All right, position 1 is a plea, position 2 is null crossed. Position 3 and 4 and 5 are waiver, and 6 are waivers of arraignment and further notice for trial. 7 is a null cross, 8 is a plea, 9 is a plea, 10 is null cross, 11 is a plea. 12, Willie Donaldson. How are we proceeding on that one?
Your Honor, I believe that was a waiver of presence and arraignment that I'll submit to the court once I leave the courtroom.
All right, so this is a waiver arraignment and further notice for trial. Same announcement for position 13 and 14. I believe Ms. Elsner's bond was modified. So,
yes.
Okay. Position 15, Frazier was a plea. 16, Garrison was a plea.
Your Honor, position 15, we withdrew the plea, and I'm going to submit a waiver for that.
Oh, yeah, you're sorry. Yep, you're right. I forgot to cross out the plea part. Yep, but you did file a waiver arraignment and the case is further notice for trial. Position 16 is a plea, 17 is null cross, 18 is a plea, 19, Griggs is released. So that's further notice for trial. 20, Hardnett is a plea. 21 is a waiver arraignment and further notice for trial. And this is for both cases. The current one on the calendar and 23 CR 002-885B.
Understood. Your Honor, could I wrote the conditions down, but could you give me the conditions again just to make sure I got them all for that case? That bond modification?
Yeah, I modified it to a signature bond for pretrial. I believe it was no driving unless you have a valid driver's license, insurance and registration, and no alcohol and no illegal drugs.
Thank you, Your Honor.
And current mailing.
Your Honor, I'm sorry, what position is this?
This is for position 21, Jordan Harvey.
Okay, okay.
And position 22, I guess, that's where we modified the bench warrant, the $3,000 bench warrant, okay? 23, Kathleen Hunt, what are we doing?
She
Oh,
has
she
been,
was released, excuse me. She was released, so that's further notice for trial. Position 25 and 26, he has been released, and that's further notice for trial. Position 27, Marquez King,
Present.
okay. Mr. Marquez King is.
Oh, Judge, that's my case. I'm here for Mr. King. That's position 27, 28, and 29. I'm just waiting for them to bring him from the jail or to go to him to the jail. Oh, he's in medical. I see him.
He's at the medical unit. Do you need to speak with him?
No, Judge.
All right. This is State versus Marquez King, who is at the medical Zoom panel. Case number 23 CR 3705F, in which he's accused of battery from May 7, 2023. His second case is 23 CR 5468F. He's got 2 counts of simple battery, and that's from May 27, 2023. He's got a third case, Marquez King, and it's a battery of a particular nature. We're going to waive sounding. And that's from September 26, 2020. And these are the 3 open cases with regards to Marquez King. Mr. King, my name is Judge Law. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. And currently, your attorney is Miss Catrice Helen, who is on the Zoom session. Do you see her, Mr. King? All right. Miss Helen, how are we proceeding with Marquez King's 3 cases?
I spoke to Mr. King this past Monday as well as last Monday. I just want to say thank you for him appearing last Tuesday. He did not appear, but today, Judge, we wanted to enter pleas of not guilty. We're going to ask that this case be arraigned and then be set for jury trials, all 3. But I do have a bond request for all 3, Judge.
So do you waive a sounding of the accusations?
I do, Judge.
All right. Mr. Marquez King, as I already mentioned, you have these 3 open cases, which involve the 1 count of misdemeanor battery from May 7, 2023 in Fulton County, Georgia, 2 counts of simple battery from May 27, 2023 in Fulton County, Georgia, and a 3rd battery charge of a particular nature from September 26, 2020, also a misdemeanor offense. With regards to all misdemeanor offenses, these accusations have been filed, and the cases are going to be further noticed for trial. At the time of the trial, the prosecutor has the complete burden to prove all charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. At the time of trial, if the prosecutor does prevail and does prove one or more of these charges beyond a reasonable doubt, you will be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. These sentences could be served separately or concurrently. Given this information, Mr. King, how do you plead to the charges brought against you? All right. All 3 cases have been arraigned. All right, Miss Helen, what are the bond amounts in these cases, and what is the reason for a modification?
Yes, Judge, for position 27, I have that it's currently a $3,000 good bond. I do not have a record from Odyssey what the bond is for position 28. I didn't see the order of bond posted there, so if the state could help me with that bond for that particular case. But on position 29, I see that he has a $1,000 SOB, but also for position 29, there's a failure to appear, and that has a $500 surety bond.
All right.
And my first argument is for the FTA. Could we modify that to a SOB? That FTA was from a status conference calendar from April 6, 2023. But he has been incarcerated since June 11th of 2023 for a total of 381 days. So we are asking for that bond to be modified. For petition 28, excuse me, does the state have the bond for that? I can't see it reflected on Odyssey.
I've just been looking through Odyssey myself, and I also do not see a bond amount for that case, nor do I see a bond order.
I was going to say, Judge, is there a way the court, I'm just going to request that, again, it be a reflective 1,000 SOB bond as reflected in position 29. Then also for position 27, Judge, it's a $3,000 good bond. That was set by Judge Morrow. However, Judge, I am asking that all three bonds reflect an SOB status for Mr. King. He has been incarcerated for 381 days since June 11th of 2023. And going by the Ayala factors, he doesn't know any of the individuals in the cases. I have looked at his history. It is extensive, Judge. I am agreeing with that. However, he is also residentially challenged. However, he has been found competent as of September 2023.
Okay. Anything else?
Yes, Judge, I apologize. I just was making sure I covered everything. He is 41 years old and he's not currently working.
I think position 28 was a bind over. So that might be why we are unable to see the bond amount.
Okay. Ms. Mulcahy?
Yes, Your Honor. Given the defendant's history, some of which is violent, the state does believe that the bond amounts are appropriate as they stand.
Right. The battery charge, the bond is going to be amended to a $3,000 signature bond through the jail. The bench warrant is going to be amended to a $2,000 signature bond through the jail. No contact with the alleged victim and stay away from the incident location. And I honestly, let me see.
And Your Honor, if I may speak as well regarding this case, Ms. Helen and Ms. Mulcahy.
Yes, what's your position in this case?
Yes, Your Honor, I represent Grady Health System, Grady EMS, and the victim in, I think it's position 29. It's the 2020 case. Mr. King, unfortunately, is a high utilizer of our services. And
can I finish my terms on my bond?
Yes, I'm sorry.
I'll finish the grid. So I was just looking up to see looks like the $3,000 good bond was with regards to a Waffle House and a Tamanika Williams. Okay, all right. Go ahead, Ms. Johnson.
I'm sorry, Your Honor. I was going to say, Mr. King has been a high utilizer of our services. And of course, we don't turn people away. We're not going to turn people away, but there are certain precautions that we as a hospital and an EMS service would like to be able to take when and if Mr. King calls, particularly as the allegation has to do with an assault on one of our paramedics. And he does have a history of other assaults and obstructions of firefighters and police.
Are we talking about the September 2020 incident?
Yes, Your Honor.
Okay. Go ahead and tell me, what does the hospital want to do?
We need something in an order that we can provide to our public safety and to our 911 folks so that when Mr. King presents to the hospital or calls 911, that we can provide and ask for additional resources on those calls.
Ms. Johnson, that's very aspirational, but I don't think Grady is a stranger to some interesting and challenging cases. Could
Your-
you articulate more specifically, how do you all address these challenging cases?
We would like to be able to have a co-response from police for 911 calls, and we would like to have something to give our public safety team at the hospital to be aware that they should be present when he presents to the emergency room.
All right. Miss Helen, do you have any comment?
I just want to first tell Ms. Johnson thank you. She's been present for all of the court appearances, and she is correct. I think she's a representative over the EMT mentioned in position 20. But Judge, I agree. I think something should be in the bond order for the EMT to receive additional help or assistance in that case, because one of my concerns was, how are the EMTs or anyone else of service protected? Because I want them to also know that that's important.
All right, Mr. With regards to case from position 29, we're going to issue a bond modification. All conditions of his bond remain the same. He's got an FTA of a $500 surety, so now that's going to be amended to a 500 signature bond with the jail. He is to stay away from all Grady Hospital property unless he is seeking emergency treatment or he has a specific appointment with a healthcare provider. When he is entering or brought into the facility, Grady is permitted to restrain him. Mr. King, if you ever enter a Grady Hospital or a Grady Healthcare Service location, the Grady Hospital system is allowed to restrain you. Do you understand?
Yes, ma'am. Yes, ma'am.
And there shall be no improper contact between you and any of the Grady hospital staff. The restraints will be in accordance with the court order, as well as with regards to any primary medical doctor's instructions.
Thank you, Your Honor. And obviously, all of that would be in accordance with his medical condition and anything that he required at the time, and with good medical practice and judgment.
Correct. I trust Grady has had a long time experience with their public security staff. So when I say restraint, they will use the appropriate level of restraint given Mr. King's conduct at the Grady facility.
Yes, Your Honor.
All right. Ms. Helen, please make sure that is in the bond order for position 29, and then no contact with Tamanika Jones and Waffle House in position 27.
I apologize, Judge. I'm so glad you brought that back up. I just wanted to make sure I got everything correct for that bond modification that I'm going to be sending. Grady can restrain him. He has to adhere to the primary medical doctor's instructions, stay consistent with the current medicines that he's on, and that he has to stay away from all Grady locations unless having a specific appointment or an emergency medical situation.
Correct.
Thank you, Judge.
And he can be restrained anytime by the Grady staff. So that's a given. All right, thank you. Next, so Marquez King is a waiver of arraignment and further notice for trial for positions 27, 28, and 29. Thank you, Mr. King. That concludes your cases. On position 30, James Lacey. Thank you, Ms. Johnson. Did you have
Thank you, Your Honor. I appreciate it. Have a good day.
You too. Thank you.
I have an announcement. Position number 3, Mr. Baker, he's downtown in court. Miss Helen, do you need Mr. Hall to add on number 1?
I don't believe I have any additional cases other than Mr. King.
Deputy, with regards to Sidney Baker, all his cases are further notice for trial. So he doesn't need to be brought back.
Position number 3, Your Honor, is Jamal Baker.
Jamal Baker, number 3.
Position, that's right, it's Jamal Baker, not Sidney Baker. So what are we doing for Jamal Baker? I think it was Mr. Dotis, was it?
Your Honor, Mr. Baker needs a conflict attorney. It should be Ms. McLeod, I think.
Okay. I'm gonna reset position 3, Jamal Baker, to July 2nd. And please ask Ms. McLeod to speak to her client. I'll appoint her to the case.
Judge, I'll let Ms. McLeod know. She was on the line earlier. but
She
had-
was.
She had to represent him. She had another court hearing. So I'll
Right.
have her and let her know that he's reset to next week.
All right, thank you. Okay.
So who's representing position number 1 on the add-on calendar, Mr. Michael Hall?
Oh, that was Miss Vigilante, I believe.
Miss
and that-
Vigilante, do you need him? Because we're gonna try to get him. If he refuses, we're not gonna force him to come.
He's reset to July 2nd.
Okay, all right,
Thank you. Okay.
Oh, she's the
All right, so moving on to position 30, James Lacy, Miss Vigilante, or Mr. Dotis, what are we doing in that case? Oh, he was released, okay. So that's further notice for trial. Position 31 was a waiver of arraignment and further notice for trial. 32 is amended to a $2,000 signature bond through the jail. Position 33, Jimmy McKinnon, is 34, 35. Are all waiver of arraignments and further notice for trial. Position 36, Jamal Muhammad, 36 and 37, a waiver of arraignments and further notice for trial. Position 38, Chad Murray, is reset to June 27, this Thursday, as an add-on. Position 39, Derek Rogers, what are we doing?
Your Honor, I'd like to request a 1-week reset. Mr. Rogers did not want to come to court today, and so our social worker is going to speak to him.
Case is reset to July 2nd at 9 a.m. Position 40 and 41. Position 40 is a waiver arraignment and further notice for trial. In position 41, the bench warrant is vacated and set aside. Position 42, that case has already been arraigned and further notice for trial, and private counsel has entered an appearance yesterday, Mr. Majeski. Position 43, Strozier, is a waiver of arraignment and further notice for trial. Same announcement for 44. Position 45 was a plea. 46 is null pros. 47 is a waiver of arraignment and further notice for trial. And same announcement for 48, Woodard, waiver arraignment and further notice for trial. I believe that concludes the calendars.
Your Honor, I believe that the officers are still trying to see if we can get Craig Washington, position 2 on the add-on. I know you did say that you're willing to reset him. Should we allow them that opportunity to try to retrieve him, or?
We're going to reset the case.
Okay.
And that's going to be reset to July 2nd.
Understood. Thank you, Judge.
And Judge, those are all the positions I have. May I be excused?
Yes, thank you.
Thank you, Judge.
All right, Ms. Kaki, Ms. Ham, you all enjoy your week, and I'll see you maybe Thursday. All right, you all take care. Thank you. Thank you, Ms. Vigilante, Mr. Dotis. You all have a good one. Ms. Champion, we good?
Yes, ma'am.
All right, I don't know if anyone's at medical. Is anyone at medical? No? All right, court's concluded. Thank you so much, everyone. Bye-bye.